Hey everybody, estate planning attorney Paul Rabelais here. Good to see you again. Good to have everybody on board, especially Larry. Great to have you. Kind of a last minute scheduled um, live stream here, but miss you guys. Been out of town. I've went to see my son who's in law school in the state of Oregon. Went to a wedding for a family member in Texas. So it's been a few days since I've put on these live streams. So good to be back. Thought I'd throw one together right here while I had a free evening. All right, so this one's all about how to keep the heirs from splitting hairs. But it really is unfortunate that that people see so much of this family members fighting over an inheritance. It just it rips me apart. But the reality of it is, families fight. Why do families fight? Why do surviving siblings, surviving loved ones? Why do they fight? I think it's a variety of reasons. If you feel free to contribute what you think in the live chat, but it might be greed. It might be issues that have been simmering for years. Might be old grudges. Sometimes the deceased contributed to the problem that encourages survivors to bicker. Some people have a belief that they just inherently deserve things or deserve more that they otherwise are entitled to. And often in these rivalries and these will contests and these estate settlement contests, very often no one wins, except maybe the litigation attorneys who are representing the parties who are involved. So I want to go through, rather than just how to deal with it when it's already a mess. I'm trying to nip this thing in the bud. How do you arrange things to minimize the likelihood that there's going to be the all out World War III when somebody passes away? So that's what we'll get into. I've come up with 7 or 8 different topics that I want to address that are related to preventing the family fights. It's recognizing underlying family conflicts, create your estate plan accordingly. Don't give others a easy, valid reason to contest something. Keep the estate out of probate. Clearly communicate specific wishes that you have. Appoint the right decision makers. Perhaps consider doing some gifting during your lifetime. And then also, after someone dies, what's the easiest way to make sure those good relationships continue throughout the estate settlement? So hello to Larry, hello to Asher, and hello to Ann. Good to have all of you. If you're on board here and you'd like to contribute to the chat, we welcome it. That's the whole idea why I do the live stream, to get some of you who are in the kind of community here to contribute with your comments, your experiences, your sharing. I'll present some information, then I'll head over to the chat in maybe 20 minutes or so, and we'll address that. All right, try to keep the comments all positive and constructive. All right, so maybe this is for people who are they're alive and well, and they want to make sure that they keep everything in the family. They keep those family relationships strong. They don't create a monster that triggers some type of conflict. So I've put together, like I said, a few points, and I want to go in deep, a little bit deep with each of those points. So the first one is recognize those underlying family conflicts. You may be getting signals from some heirs, maybe some as direct as from a child, or sometimes from a spouse of a child who kind of needs to mind their own business. But sometimes a spouse of a child may say, I'm going to make sure we contest this when you pass away. Or maybe a child says, I don't agree that what you did is right, or I don't think it's fair that someone should get more. Maybe you're setting things up so you want certain people to get more than others. You may want certain children to get more than others. It's your right to do it, and there's nothing says you have to be equal. It may be appropriate that someone gets more, but maybe someone says, I don't think that's fair that someone gets more. I'm going to contest. Or maybe someone says, I don't think it's fair. And look, fair, what an heir perceives as fair is not the determining factor here when it comes to settling an estate. But it's just statements that we hear all the time. I don't think it's fair that that you've done more for my brother. You paid for his college education. You paid for him to start a business. You paid for his kids' education. I don't think that's fair that you've done more for my brother during your lifetime, and then he still gets an equal share when you pass away. I don't think that's fair. So sometimes you hear stuff like that, and again, what someone, I'll repeat it, because what someone perceives, what a future heir perceives as fair is not what controls here. This is your estate. You get to call the shots. Are there certain limitations? There are certain limitations, but in general, you get to do what you want. And I will say this. I get these questions all the time. I'm having these Zoom meetings with clients around the country. Someone will often say, Paul, can anybody just contest my estate? And I don't really like when I get that question. We do live in America where it's pretty easy to file a lawsuit against just about anybody for just about anything. But the wrong question when someone asks me in an estate planning concept, the wrong question is, can someone contest what I'm doing? But the real question would be, can someone successfully contest what I'm doing? Because it's pretty easy for someone to file a lawsuit, but the problem is for them to be successful, they have to be able to win on the merits. So someone can't just say, I'm contesting, I'm declaring that my father's will is invalid because I'm contesting it. That will never fly. So that person who's contesting has to have a valid reason to contest, and enough so much that a judge would say, right, on basis on the argument that you made and the law that exists, you're right. Your contest can be in part successful. So that's the thing. Can someone successfully contest if they do contest? All right. So let's move on to what can you do to create your estate plan in a way that minimizes the likelihood that there will be a contest when you pass away? Well, speak of the devil. You can create what's called a no contest clause. Now, the validity of no contest clauses varies from state to state. Sometimes they're in some states they're unenforceable, in some states they're enforceable, but in some states they're enforceable, but an heir can still contest perhaps a fraud or make a fraud or undue influence claim. So you have to look as far as whether the no contest clause is valid. You have to look at each state law or the state law where the person who wrote the will or trust is domiciled. But nonetheless, if sometimes even if it's in a state where the no contest clause is unenforceable, the fact that a no contest clause exists in a will or trust can be enough for that heir to say, look, my lawyer told me that these no contest clauses are unenforceable, but my parent did it anyway. I think I'm going to back off and be a little reluctant because that no contest clause is in the will or in the trust. So generally speaking, it doesn't hurt to have the no contest clause as part of the estate planning documents, but just realize the validity of it may be due in large part to what state that action may be taken in. Another thing to do when you create your estate plan accordingly is make sure you're aware of perhaps if you're married, how you're leaving things to a spouse. Many of us have heard of the scenario where husband dies, leaves everything to his wife. Maybe the couple had children of the one marriage. Maybe it was a blended family where the husband had his own children, wife had his own children, but nonetheless, for whatever reason, the husband said, when I pass away, if I predecease my wife, I want everything to go to her. So be careful about that, because sometimes that surviving spouse, life will go on, life events will change, family circumstances change. And if the husband leaves everything he owns to his wife, then the wife has the right to do whatever she wants to with the entire estate when she dies, including disinheriting the husband's children. So that can cause some real animosity between the husband's children and that surviving wife. Sometimes it's a stepmother, sometimes it's a mother. But perhaps if you are going to leave everything to your spouse, maybe you communicate that to your kids. Hey, kids, here's my decision. I've made it, and I'm going to leave everything to my surviving spouse. You can like it or not, but I've made an informed decision. It's what I'm going to do. I'm expecting you to honor your wishes, honor my wishes. And so, again, just be careful on how you leave things to your spouse, particularly if you would want things to go to your children or other heirs after you and your spouse pass away. So create that carefully. Also, you want to To avoid animosity, oftentimes protect the inheritance of the children. Many people tell me, Paul, I want my children to inherit, but I don't want their spouses to inherit. So that causes us to create the children's inheritance trust, so that when a child inherits, it doesn't get commingled or mixed up with assets they have with their spouse. It goes into a trust. And that way, the spouses of your heirs, the spouses of your children, never have any ownership rights to what you leave behind. So worked in a scenario today where people said, Paul, we want assets to go to our children, but when our children pass away, we want to be very particular about what happens with those assets. So leaving assets to a trust for your children can allow you to have a little more control over those assets, not only while your children are alive, but also when your children pass away. So make sure you create that accordingly. A real conflict can be created when you do leave your assets in trust for your spouse. Many people create the whole Q-tip trust arrangement. Q-tip is a tax term, but there's many non-tax reasons to create that arrangement where you're married, you leave your estate to a trust for your spouse, but when your spouse later dies, those assets revert back to your children. And so it can certainly create some conflict if you name your spouse as the trustee of that spouse and you give your spouse the authority to take distributions from that trust for your spouse's health, education, maintenance, and support after you pass away. Now you've got an arrangement where husband dies, he leaves his assets to his surviving spouse in a trust so that the future inheritance rights of the husband's children appear to be protected. But the husband left those assets in a trust for the wife, named the wife as the trustee, and gave her the discretion to take distributions from that trust. Now, if that relationship turns sour, or maybe if it doesn't turn sour, that surviving spouse may abuse their discretion as the trustee, create some real conflict there between that surviving spouse and the principal beneficiaries of that trust. So in that case, if you want to avoid that potential conflict, maybe husband would name someone else as a co-trustee of that trust with the spouse, so the two of them would have to agree to make distributions from that trust to the surviving spouse, or maybe the surviving spouse is not a trustee or co-trustee at all. So anyway, there's some areas in estate planning where you can create some conflict of interest after you pass away. And if you want to avoid that conflict, maybe you look for solutions where there isn't that underlying family conflict. All right. Next, I want to go over to, this is probably one of the biggest ones. Don't give your future heirs a valid reason to create a contest or to create conflict. Let me give you some examples. Number one, you want to make sure all the validity requirements that you need to meet are met. If in order to create what you're trying to create, things have to be notarized, make sure they get notarized. If they have to be witnessed by two people, make sure they're witnessed by two people. If they have to be witnessed by people who are not related to you, make sure you follow those validity requirements. Yeah, some of this stuff, the attorney should be guiding you through that, and the attorney should be aware of all of the validity requirement rules. If a certain document that you're creating needs to be signed on each page, make sure it gets signed on each page. If it has to be initialed in certain places, make sure you initial. So you want to make sure all those validity requirements that you need to meet are met. Number two, this is a big one. I just can't stand it. It just tears me up when I get the call, probably from a child, of someone who says, Paul, you know, my father's not doing well. He had a stroke 6 months ago. He's been in the hospital. You know, he's in and out of it as far as being able to make good decisions, but he's never did his estate plan. He's 87 years old. He never did anything. He was stubborn as a mule. And so I don't even want to get involved in that, because now you're creating a situation where, one, really uncomfortable for everybody involved to be kind of shoving legal documents in front of someone who's in their final days, final weeks, with questionable capacity. I can't stand it. I don't do it. And then, you know, so you're just, you know, you're asking for this potential contest for lack of capacity. Make sure you do this. We realize estate planning is an area where people procrastinate. But geez, and by the time you're 60 years old, even 70 years old, if you haven't tackled this thing while your capacity is good, put it high on the to-do list, create a sense of urgency, and get this stuff taken care of, because nothing's worse than waiting until the very last minute when really people's days are numbered, and it's just a really uncomfortable situation for everybody involved. Another thing you want to do to avoid giving people a legal reason to create a contest after you pass away is don't either be unduly influenced or coerced, or don't even appear to be unduly influenced or coerced. So had the situation many times, daughter brings mom to the lawyer, daughter introduces mom to the lawyer, daughter kind of butts herself into the whole conversation between mom and attorney. Mom ends up writing estate documents, perhaps leaving the home to guess who? Daughter. Or leaving the investment account solely to guess who? Daughter. And then maybe other children get other things of lesser value. But that certainly appears funny. It appears to look funny because daughter, who's getting more, arranged the whole thing, was part of the conversations. Yes, formally she wasn't a notary or a witness or never signed any of the paperwork, but it can certainly appear enough that there's the appearance that there's something improper here, that maybe that daughter unduly influenced or coerced mom into doing something that mom wouldn't have done if daughter was not part of that conversation. So that's why I mentioned don't be influenced, but don't even appear to be influenced, particularly if that person who is influencing or appears to be influencing somehow gets some financial advantage at the end of the day. So make sure you don't do that. And then another part of the lawyer's job is, and don't give them a valid legal reason to contest, is don't create vague language. Sometimes I'll see these documents come across my screen or my desk, and it'll say, I leave my business to Fred. Well, the guy had 6 businesses. So there's vagueness and there's ambiguity. Or I give my money to my son, Sam. Well, what is your money? Yeah, you have some checking accounts and savings accounts and CDs. Is that your money? What about your investment accounts or the stock that you own or mutual fund shares? Is that your money? So can't be vague, can't be ambiguous. Want to make sure with what you're doing, it's very clear, and avoid the possibility that there will be a contest. All right, next step on making sure that estate settlement chaos is avoided is perhaps keeping the estate out of probate. Whenever there's a probate when somebody dies, some of them go very smooth. Some of them are an absolute nightmare. And then there's all kinds of in between. But generally the way probate usually goes, it takes some time. There is some expense. There's a lot of court paperwork that gets prepared. All the heirs have to sign off on various court pleadings and court paperwork that sometimes is confusing and heirs don't understand. Sometimes they're represented by lawyers. Sometimes they're not. As dear Abby said, if you ever want to really get to know someone, share an inheritance with them. As you might be able to start imagining, when you have this process that requires lawyers and the government and judges and large corporations and heirs who are sharing a pot of money, when you involve a process that involves that many people, there's just for any number of reasons, either because of delay or whatever reason, there's likely to be some stress, and that stress creates conflict, as opposed to maybe dad who had $1 million IRA and he named his 4 kids as the beneficiaries of his IRA. Each kid can go sign their paperwork at the financial institution after dad dies. Each kid gets their 1/4 of the account in an inherited IRA. There's no government and there's no lawyers overseeing any of that. So by keeping things out of the court system, you may be eliminating an estate settlement contest. How do you keep things out of court? Well, there are many types of assets that you have where you can simply name a beneficiary. I mentioned the IRA, I mentioned the life insurance, lots of financial accounts, whether it's bank accounts and credit unions where you can make POD designations, whether it's stock accounts or investment accounts where you can make TOD designations. All those things get settled when you pass away outside of the formal court and lawyer involved probate proceeding. Real popular probate avoidance tool these days is that revocable living trust. Probate governs the assets that are in your name when you pass away, assuming there's no beneficiary. What many people do is they take those assets that would have to go through probate, they create their living trust, they transfer those assets to their living trust so that when they die, their assets are owned in their trust. Assets in their trust don't have to go through the court and attorney involved probate process when you pass away. And in your living trust, you designate a successor trustee whose job it is to settle things, make sure assets are transferred to the appropriate trust beneficiaries, all done outside of that court and lawyer involvement. So a big part of our business around the country and our national estate planning law firm is creating these living trusts for individuals and couples around the country. Real popular. Another piece of making sure estate conflict is avoided when you pass away is communicating your specific wishes. I'll touch on one little aspect of that is the personal effects. Sometimes the personal effects make up maybe 1% of the overall estate value. Someone may die with a $3 million estate and have not more than $30,000 of personal effects. Makes up less than 1% of the overall estate value, but it created 99% of the conflict after someone dies. Because if you have 3 heirs and you have accounts that are worth $2.4 million, it's pretty easy to divide that up 3 ways. Everybody gets $800,000. But when you have a diamond engagement ring and the expensive gun collection and the other whatever non-titled personal effects, and because there's a little bit of internal conflict among those survivors going on, that stuff can rear its ugly head in the distribution of the personal effects. So sometimes you need to be specific, either in the estate planning documents, particularly if you want to make sure that certain people get specific things. Many states allow you to create these tangible personal property memorandum where you can create a schedule as to who gets what personal item or personal property. Or maybe you just leave informal instruction. I've heard it 1,000 times where Paul said, where people have told me, they said, Paul, I'm not worried about how my personal effects get distributed. And they'll tell me, Paul, those little sticky notes that people have, I took a stack of sticky notes and I went around my house, and on the back of each painting and picture and furniture, I put somebody's name on the sticky note and I put it right there on that thing. So the sticky note process is not necessarily a valid way to do it, but nonetheless, people do it all the time. At least they attempted to communicate. Sometimes when you communicate things like that, even if it's not in the formal valid way to do it, sometimes those surviving family members will honor your wishes when they see that you've made an attempt to communicate what you want to happen. But another aspect of clearly communicating what you want to accomplish, and I know this is blunt, but you know what? In 3 minutes, you could take the time to avoid what could be months or years of conflict that would cost hundreds of thousands of dollars when you pass away. And I know some people take the position, I don't want my kids to know anything about my estate. I want them to wait until I pass away before they know anything about what I have, who I've appointed to handle things, and how I'm leaving everything behind. I certainly don't want them to know any of that while I'm alive. If that's your position, can't argue with it. You feel strongly about that. But other people say, you know what, I'm going to share, once I get this straight, I'm going to share everything with my children. I'm going to go over what I have. I'm going to go through all the decisions. And so for those people, and generally speaking, the more communication, the less likelihood of conflict. It's not a 100% automatic rule. But maybe you do have 3 children. Let's call them ABC, Allison, Bruce, and Charles. And maybe you tell them something like, hey guys, let's all get together and I want to discuss my estate planning with my 3 children. Look, and when you all get together, You might say something like, hey guys, look, I love all of you and I want to communicate what I've done because I don't want you to bicker when I die. And I want to give you an opportunity to ask me questions. And then you go on. You say, you know what, guys, I made Allison as my healthcare proxy because she's in the medical field and I want her involved in my medical treatment decisions. And then, guys, you know what else? When I die, or if at some point during my lifetime I can't, deal with my accounts, I've designated Bruce to handle those things. And when I die, I want Charles, my youngest son, to have my extensive gun collection. And you know what, guys? I'm leaving $100,000 to each of my grandchildren, even though Allison has 6 kids and Bruce only has 1. The rest, I'm going to leave equally to the 3 of you. Now, I realize I own a business that can be hard to divide up. So I'm leaving my business in a trust for my 3 children, but I'm designating Bruce as the trustee of that trust that will continue to own my business when I die. So Bruce can make all the management decisions and call all the shots for my business. And then, the 3 of you will be treated financially equally as far as any kind of dividends or income that my business produces. Now, what that dad may say is the main reason I'm telling you this is because I expect you to honor my wishes when I'm not around. Now, if any of you have any questions, now's the time to ask while we're all here. So what questions do you have? And oh, by the way, I put a no contest clause in my estate documents so that if any of you challenge what I've done, you get nothing. And maybe you even record that conversation. They're going to have questions. They're likely to have questions unless they're just intimidated by all get out from what you just told them. But they're likely to have questions. Maybe it's about your business or why you did certain things. And, maybe Bruce, who only has 1 children, might say something like, well, Dad, that doesn't seem fair. You're leaving $100,000 to each of your grandchildren. Allison has 6 kids and I only have 1. That doesn't seem fair. And you know what your response to that? If this response is appropriate, I hear you, Bruce, but it's my estate. I get to do what I want to do. Allison has 6 grandchildren. I'm leaving them each $100,000. You have 1 child. Your child's going to get $100,000. And yes, the result of that is Allison's family gets more than you and your family. Next question. So, that pretty much nips it in the bud. So now when Dad dies and Bruce wants to say, wait a second, that's not fair. I'm not signing off anything. Can always go back to that conversation. Bruce, you were around when you asked Dad that specific question and he addressed it. We've even got an audio recording. And so maybe you do record that, not so much for evidentiary purposes, but for just avoiding the he said, she said thing, years later. So I love the idea of just parents who get to call all of the shots when it comes to estate planning, having that open dialogue and not only explaining kind of what they've done, but why they've done it. And they've given all those future heirs an opportunity to ask questions, get those questions addressed. Maybe there's a question from the children where a parent might say, you know what, I'm not going to answer that. I did it because I wanted to. Next question. But great opportunity that 5 minutes of communication could eliminate much conflict in the future. So that's important. Next thing is making sure you appoint the right decision makers to handle things in the future. When you create your estate plan, you've got to make a bunch of decisions. One, who's going to be your executor of your will when you pass away? And if you have a living trust, who's going to be your successor trustee? Is it going to be one person or is it going to be 2 or more people? Too many people make the mistake of making those appointments based on, I don't want to hurt someone's feelings. That's a really important job where you're appointing someone to get your estate settled when you pass away. And so appointing the right person is key. And that right person is likely to be the perfect person, is likely to be someone who's organized, good communicator, good relationship with all of the people and the third parties and the organizations that are involved. They get things done. And so you're going to want to make sure you make that right appointment. Appointing the wrong person where they incur delay, there's confusion, there's mistakes are made. You're just asking for trouble by appointing the wrong person or the wrong people. So make sure you make these appointments that and in light of what's in the best interest of your estate and yourself and your surviving family members, instead of making those decisions based on this person might get their feelings hurt if I don't appoint them to play a role. So these are big jobs. They're important jobs. Sometimes they affect millions of dollars, sometimes tens of millions or more. People have to have an understanding of finance and tax and law and real estate and business to be able to do the job properly. You may need to make sure you appoint the right people. And then you'll also be making appointments of people who will have the authority to make decisions for you while you're alive. If at some point during your lifetime you can't make your own decisions, and you can't go file your taxes, and you can't make withdrawals from your accounts to pay for bills that you have. But you want to, in those durable powers of attorney, those healthcare documents, advanced healthcare directives, healthcare power of attorney, you want to make sure you appoint the right people who are going to do what's in your best interest and have the skills and ability to do that right. So make sure you make all the right appointments when it comes to making those decisions when creating your estate plan. One other thought on perhaps avoiding conflict in the future is, and look, there's pros and cons to this, of this making gifts during your lifetime. On the one hand, I like the idea of the multimillionaire making some gifts to their children, to their grandchildren during their lifetime, just to see how the children are going to do, to see, what kind of comments the children, the grandchildren are going to make as a result of what could be those $18,000 present interest annual exclusion gifts that might get made every year. Some people don't want to do the gifting because, quite frankly, and I don't blame them for thinking this, some people don't want to do the gifting of, $18,000 or some amount to all of the children or the grandchildren while you're alive because you fear that you might run out of money. We don't know what our future expenses will be, especially future medical expenses, particularly if you need long-term care for many, many years and you're getting that care in your home or in some facility. We're talking in many cases tens of thousands of dollars monthly if that goes on for years. So I don't blame the people who say, no, I really don't want to do any gifting during my lifetime because I feel like I need to stay in control of what I have because I don't know what I'll need in the future. But some say, let me do some gifting to my children. I'd like them to see them enjoy it while I'm alive. I'd like to see how they react to it. And that might impact how I leave the rest of my estate when I pass away. So that's one small piece of making sure that there's no conflict when you pass away. Then the last piece I'm going to go over is what happens when you pass away. So you may have little or no control over this piece as the person who created the estate plan. But I've been involved in hundreds or thousands of these estate settlements after someone passed away. And it just seems to go a lot cleaner with a lot less animosity, a lot less rivalry. If shortly after dad dies, for example, we get all of the estate settlement participants together. Because oftentimes, yes, we could read the will like they do in the movies. Yes, we could email a copy of the will or the trust. And then every participant is on their own trying to read and interpret a bunch of legal gobbledygook. But so generally what we like to do, get everybody together. Zoom is great for this because sometimes heirs are around the country. Dad dies. He's got 5 kids. All right, 5 kids. We're getting together on Tuesday at 5 p.m. And I'm going to go through with you the relevant provisions of all of the estate documents. We're going to go through the assets that are there. We're going to go through the steps that are involved in making sure everything gets settled correctly. And then we're going to open up for questions and make sure everybody agrees on the plan that we're about to implement. That's going to take some time. But if we can get everybody in agreement on the implementation of a plan, it will go a lot faster than if some of you don't agree on the implementation of a plan. So I might tell that crew, it might be Allison, Bruce, and Charles. Look, I'm sorry to hear Dad died. Let's all get on a Zoom. And here's what your dad did. He said that when he passed away, he left $100,000 to each of the grandchildren. So I realize Allison has 6 and Bruce has 1. But, $100,000 is going to go to each of Allison's 6 children because that's what dad wanted and that's what he implemented. And then he said he left his business in a trust so that Bruce can be the trustee of that trust. So Bruce can make all of the management decisions of that business for the benefit of the 3 of you. Now that your dad has since passed away, Bruce is going to call the shots on the business, although it's in a trust for the benefit of the 3 of you. And hey, look, guys, he left Charles all of his gun collection. I know he has a bunch of them, and I know some of them are really valuable. And look, he may have even told somebody during his lifetime he wanted somebody to have a particular gun. But you know what he said doesn't really matter now. The legal documents say the guns go to Charles. Charles gets the guns. So guys, with all that being said, that's what your dad did. Here's the steps of getting everything done. Bruce, as the trustee, is going to start setting up some trust accounts and moving money into the trust account. He's going to reimburse himself for the funeral arrangements that he made. That's going to be well documented. He's going to pay dad's credit card bills. He's going to pay any other debts that dad died. And then once we get all that straight, then it's going to be a process of starting to just, and in addition, Bruce, as the trustee or the executor, is going to make a decision about whether the house is going to be sold. Maybe he'll ask you for your input, but he doesn't have to. He's the trustee. And then once all that's settled, then there's going to be a process where we'll start distributing the assets to the 3 children equally after all of that other stuff is handled. And, hey, guys, we'll get on a group email. You'll be in on every email, every communication. One of you can't call me and say, don't tell my sibling I'm calling you, but I'll hang up. Because we want everything to be open. We want that communication to be clear. We don't want any of you to think that something's going on behind your back. So everybody's going to be a part of every estate settlement communication. If it's an email, it's got to be to the group. If somebody needs to talk about something, we'll all hop on a Zoom call and we'll all talk through it. And boy, when you see, those heirs that might suspect something's going on, when they start to hear that and know that they're going to be included and they know there's not going to be any secrets, then you just start seeing their shoulders drop and they're like, okay, I think we're on the right path here, because everybody agrees that, we have a plan and we're going to implement it and everybody's going to be aware of it every step of the way. That kind of stuff. Now you're dead, but obviously having the right attorney involved at that point is real important. And sometimes conflict is inevitable. And when conflict is inevitable, everybody's got to get their own lawyer and the lawyer's got to fight it out. But there's a lot that can be done on the front end, really shortly after somebody dies, to really eliminate that conflict where everybody needs their own lawyer. Okay, so all that being said, what I want to do now is shoot over to the chat. Of course, like I said when we started, hey, Larry, hey, Asher, hey, Ann, hey, Leslie, hey, Paige. The fabulous 5. So fantastic. 5 of you said hey, and even Ann did her usual emoji stuff, and so did Paige. So something about it, Ann, you made me laugh the first time you did that. Starting to see some hearts fly up the screen. That's good. Paige, I'm a notary public and I do estate planning packages. I will also start helping out with EP workshops and learn as much as I can. Good, Paige. What's my comment there? My comment there is the more education people can have, the more likely they're going to make good, informed decisions as part of their estate plan. That's what this channel is all about, putting as much education out as we can out there to help people make informed decisions, because there's a lot of unknowns in estate planning. People have never done it before. They don't know what to do. They hear conflicting information. So we want to, and then they're paralyzed by their analysis. We want to avoid all that and set the record straight. What is the timeline, Catherine says, for contesting an estate? So there are some statutes of limitation. It might be so many years after a will gets filed at the courthouse. It might be so many years after a judge signs some court order or judgment. So it just depends. That's a state law issue, and it depends on what kind of contest is being brought. So, but generally, if there is going to be a contest, the earlier you get at these things, the better, so they can be addressed while the information and the facts are clear. So, but it does vary based on state law and statute of limitation rules. KJ, my parents definitely created hostility between us by carrying tales and bad mouthing us to each other. Yeah, that's what they did. That's not good. Now the hostilities, distrust, or rampant parents made matters worse. Yeah, sometimes I mentioned that earlier among the survivors, and so that's not good. So we want it to be the other way. We want the parents to contribute to relationships flourishing after parents pass away. So hope that can get worked out. How is a trust invalidated? Who says so? An attorney. Huyaha. Great name, Huyaha. So how is a trust invalidated? Well, it's invalidated if someone has a successful reason to invalidate it. So I'll give you just some example. And who says so? An attorney. So let's say there's a requirement that a trust be notarized in a particular state, but it wasn't. Or let's say it's question that goes back to my gotta follow the rules, gotta be ambiguous. Now to your question, who says so? Well, typically what happens is one party feels it should go this way, maybe a potential trustee of that trust. Another party feels, hey, this trust is invalid. And so if the parties are in disagreement, there's usually some court filing, and then it goes before a judge, and certain procedural rules are met where people have to make their argument, oftentimes in writing. And then it gets to where there's some court hearing where a judge determines, hey, what they did was valid, or hey, you know what, the rules weren't followed, and what they did is not a valid trust instrument. So that's about the best answer I can give. Jason, what do you suggest about splitting physical property between heirs, cars, antique, family heirlooms? Do these need to be referenced in the living trust? So there's different things there. Cars are titled. So, when someone has a trust and says, I leave everything to my two children equally, those cars are a titled asset. So the car either gets transferred formally to the two children, or some trustee may sell the vehicle, and then the proceeds of the sale of that get divided up among the two people. But when there's antiques, there's family heirlooms, if they are referenced in the trust, and not only referenced that they exist, but referenced as to who is to inherit those heirlooms, then you've got to follow what's referenced in the living trust. If it's just, the trust says I leave everything to my two children equally, and the person died having a bunch of antiques and family heirlooms, then in an ideal situation, those two beneficiaries get together. They tell each other, look, hey, mom left everything to the two of us equally. Yeah, I realize we've got this silver and this diamond engagement ring and all the heirlooms and the paintings on the wall. Why don't the two of us get together and just figure it out? We'll each, take possession of certain items, and we'll feel like it's fair, and we'll go our own way. So it's ideally when those family members get together and they can agree among themselves. But let's say they don't agree among themselves, then you've got to go into the formal court proceedings, and perhaps those things would need to be appraised in order to determine by a third party to determine fair market value of those things. And then if there's some trustee, there's a trustee, or ultimately maybe a judge gets involved in the disposition of those things. We don't like to see it get that far, because that means people really aren't getting along. So there's a bunch of different ways those non-titled antiques or family heirlooms can be handled. It just varies from family to family, and depends on what is owned. Hey, William, Sheila from Shreveport, good to see you. I heard there were some bad storms there today. Saw it on the news. Can you create a trust 50-50 between two siblings? So Bradley says, can you create a trust 50-50 between two siblings? So does that mean someone creates a trust so that when they die, the assets get divided among two siblings? Or does that a parent leaving things to two children who are siblings? Not really sure what you're getting at. I need to know a little more and ask a few more questions. David, glad you found it helpful. Hey, we got Arizona in the house. Good to have you home. I don't want to take a shot. I might mess it up. Can you tell us a wild inheritance story about someone who got surprised with a big, probably couldn't finish there. Sound like one of my children. Dad, can you tell me a story before I go to bed? So I have had maybe the wildest of my wild stories it was years ago. Dad died, left 4 kids. I'd say it probably started off on the wrong foot. And I had an inkling it was not going to be pretty when dad died and the funeral was scheduled, and each of the four children had their own security guard at dad's funeral to protect themselves from their siblings. I would say that was a sign that we were going to have trouble. And dad left behind about 30 different pieces of real estate, some rental property, some commercial property, some industrial property. And dad named all four of his children as the co-executors of the estate. And in this particular state where dad's probate was handled, if there was more than one executor named, all of the executors had to agree for any action to be taken. So, for example, on these 30 pieces of property that were in the estate, there were electricity bills that need to be paid, taxes that need to be paid, but nothing could get done unless all four co-executors, signed the check on behalf of the estate to pay an electricity bill. And there were 30 properties and there were tenants all over the place. And there was all kinds of management decisions that need to be made that would be difficult if one very skilled person was involved. But to have four people who involved, none of whom speak to each other, each had their own security guard at the funeral, it was an absolute nightmare for that thing to get settled. It took years and just really was a sad situation for everybody involved. Larry, what do you recommend on how to protect children's heirs of IRA, Roth, 401k to protect those funds from commingling their spouses as they can't go into a trust? Beneficiary is as separate property. Good one there, Larry. So, with the Secure Act, those assets got to come out within 10 years after the IRA owner dies, unless it's an eligible designated beneficiary, somebody who's a spouse or disabled or chronically ill beneficiary. But generally, it's going to go for the children or grandchildren. In this case, maybe children. All right, so I'm going to read between the lines, Larry. Let's say you have a child who's married. That spouse of the child is very influential on the spouse, maybe sometimes forces their spouse, to be able to do things that are not in your child's best interest. So if you name your child as a beneficiary of your IRA, Roth, or 401k, the general rules are those distributions have to be made within 10 years of the IRA owner's death, the Roth IRA owner's death, the 401k owner's death. And then it just becomes assets of the child, and maybe the child's spouse could influence them into doing something they shouldn't do. So if you're really worried about an influential spouse of a child, maybe you leave those assets to an accumulation trust so that, yes, the trust pays income tax on those distributions at higher rates than individuals would pay on those distributions, but it at least provides for ongoing management of those assets, even well beyond the 10-year period within which distributions must be made. So that could keep a child who has an influential spouse from doing something that is not in the child's best interest. So maybe the answer is that accumulation trust pays tax on the distributions, and trusts pay income tax in the highest 37% tax bracket when trusts have income that exceeds, in 2024, something like $15,200 of income for the year. So they'll likely pay tax at the highest bracket. But if it's accumulated in the trust, now you've got, you can pick the trustees who will manage that for the benefit of the child for many, many years beyond the 10-year period. So that's just one aspect. Good question, Larry. Okay, another hoo-yaha to invalidate a trust is a written analysis and conclusion required of someone can just say. So come on. And now someone can't just say, I'm raising my hand, trust is invalid, and that makes a trust invalid. Someone has to have legal authority why a trust is invalid. And then sometimes they have to, convince a judge that there's legal authority that something is invalid. And then the judge has to rule that a trust is invalid. So a trust isn't invalid just because somebody who doesn't like it says, I'm raising my hand, trust invalid. That's not what invalidates something. That, we have procedures in place so that impartial judges often make that determination of whether something's valid or invalid if there's a conflict that needs to be resolved. Jason, been watching you for 4 years now. Started watching when my dad was about to pass, and I had to step up as the head of the family and get things situated. Thank you, Paul, for your wisdom. Thank you, Jason, for listening. Makes me feel good that I may have had some small role in your role as the head of the family and getting things situated. So good to hear. Who judges capacity is based on David's question. Good question. So let's say dad dies. He created his will or trust when he was 87 years old. He died when he's 89 years old. And son who was left out of the will or trusted says, you know what dad did when he was 87 should be invalid because he didn't have the capacity to understand what he was doing. And because I'm raising this question of incapacity, if what dad did when he was 87 is invalid, I get my 1/3 share because that's what I would get if dad didn't do this. I want my 1/3. I'm questioning dad's capacity. So what has to happen there is, again, that would be something that would be handled in a judicial proceeding where those who argue that dad did have the capacity to understand what he was doing would likely get dad's medical records, maybe even get the doctors who diagnosed dad or at least saw dad around the time when he was 87 and he did what he did. Maybe the son who wants to question capacity will have their own set of doctors who can somehow make an argument that dad did not have the capacity to understand what he was doing when he was 87 and did what he did. Ultimately, a judge decides, and so that's how that goes. So that's who judges capacity. Hi to SW. Huyaha says, Jason, how are things going? And another smiley face always makes my day. Dan's great with her emojis. Jason says, great now. Past and mom's all right. Good. Read numerous. I had no idea my life would change so much when I had to take over all the investments bills. Yep. Like we said, it's a big deal. And so got to have people who are capable of and have the skills to be able to do it. Let's see. Larry and Ann exchanging highs and exchanging claps and emojis. Good. Have you done an auction system? Yep. That's another. There have been some books written about what are the different ways heirs can settle the personal effects of parents leave behind. There's auctions, there's drafts, there's all kinds of different, drawing straws. You got 3 children, child 1 picks first, then child 2, then child 3, then child 3, then child 2, then child 1. So there's all kinds of systems for dealing with that. When the sticky notes fall off, that's the problem with the sticky notes. And good point there. The sticky notes is not the end all perfect solution in every situation. Aaron says hi. Jason says interact with your trustee before you pass. And the 3 children, would it be a good idea to have the other children as backups? Yeah, always good to have backups. Sometimes people sign these estate documents, wills, trusts, and then they live for another 30, 40 years. So always good to have backups to cover things in case that the first person that you designated either can't or won't do the job that you've designated them to do. So no harm in backups. And sometimes we'll even make provisions where we allow other people to perhaps remove and replace a trustee if a trustee or executor isn't doing their job. All right. Nothing was planned after my mother passed away, says McQueen. My nine siblings agreed for me to be administrator for probate. This caused a lot of problems because nothing was planned. 3 think everything is there. All right. Good comment there. And always good. Susie, good. Crazy emoji. Susie with the crazy emojis going on. Like to see it. Lacey, another familiar name, Lacey. Hi, with regard to beneficiary, I understand a list of assets is generally part of the trust. Do you know if it's generally privileged or unprivileged, where the beneficiary can get? I would say it's not always part of the trust. Many trusts, the typical revocable living trust that parents create doesn't list any of the assets. The trust says when I die or after we both pass away, the trust assets are to be dispersed to the three beneficiaries of the trust. And then you have to go find what assets are titled in the name of the trust. So sometimes if the children don't know, you have to go to the brokerage firm or the trustee does, and you have to go to the real estate records to determine what the person owned. One thing we do in our law firm is we give people a secure online vault account where they can populate all of their assets, all of their trust assets. What are all the stock accounts, the bank accounts, the real estate, the business interests, the vehicles. They can document all of that and have it all in one central location. Works really well because sometimes it is common for, very common, for someone to say, well, Mr. Rabelais, Dad died 4 months ago. I know he had a bunch more accounts than we're seeing here because 4 years ago, he told me he had this account at ABC Bank. And, we'll look into it, and ABC Bank doesn't exist anymore, or there is no account at ABC Bank. But it is not uncommon for some beneficiary to assume that their parent or whoever had a lot more in assets that the parent actually had. Sometimes they're correct, sometimes they're not. So the more people can document and create those asset inventories, whether it's done on a spreadsheet or electronically or on paper, that can also eliminate some, let's go see if we can find other assets because we think they had more. Hey, Susie, wow from Ann. Maybe you're wowing Susie's emojis. And thanks, Larry, for being on. Larry's the MVP of our live streams, as always, from California. Good to see the West Coast being represented. Stay tuned. Don't have any more live streams scheduled, but more to come. Just check my YouTube channel from time to time. And we'll see you next time. Bye.